And our final lesson is employment discrimination, obviously also relevant to employment law. And here are federal legislation and maybe some state legislation as well that prevents employers from discriminating against people for a variety of different reasons. The origin of all this was the Civil Rights Act of 1964, which we're going to look at. Before then, it was pretty much, there was no federal regulation against employment discrimination, and there was a lot of employment discrimination out there. Discrimination based on race, discrimination based on religion, and federal law and many state laws have been trying to do whatever's possible to try to minimize that, although it probably can never be completely eliminated. The equal opportunity in employment is the concept of the right of all employees and job applicants to be treated without discrimination and to be able to sue employers in the event that there is discrimination. This is enforced by the EEOC, or the Equal Employment Opportunity Commission. This is a federal administrative agency that's responsible for enforcing employment discrimination laws. They can conduct investigations, do their own interpretations, encourage conciliation, and bring a lawsuit. The EEOC cannot actually punish employers. The EEOC cannot actually bring a judgment because they're not a court. They can, however, investigate complaints, try to convince the employers to come to a settlement, or if that fails, or if they don't think a settlement is a good idea in this case, they can file lawsuits to try to enforce the equal opportunity laws against employers. These equal opportunity laws are based on many statutes, but the grandfather statute, so to speak, was the Civil Rights Act of 1964. Title VII prohibited job discrimination in 5 protected classes: race, color, religion, gender, or national origin. Before that, there was really no law differentiating based on these things. Now, this doesn't apply to every single employer. It really only applies to a little bit larger employers, employers with 15 or more employees. It also applies to employment agencies, labor unions, state and local governments, and most federal government employment as well. So most medium or large companies are governed by the Civil Rights Act of 1964 and Title VII, which prohibits employment discrimination. What it does is it applies to any term, condition, or privilege of employment and says that you can't discriminate based on those categories: race, religion, color, gender, national origin. You can't discriminate in any of those things in terms of hiring and firing. You can't fire people or hire people more because they're of a particular race or a particular gender, whatever it is. Work rules, promotions, compensation, job training, all of these things are subject to the civil rights rules. And a Title VII employment discrimination action can be based on disparate treatment or disparate impact. Disparate treatment is when an employer intentionally treats people differently based on one of those criteria. So this is where you're talking about an individual, and disparate impact occurs when an employer discriminates an entire protected class, even if the law does not specifically intend or specifically state that it applies to a particular class. For example, as we'll see a little bit later on, let's say you have a test that you give to all employees and say, well, every employee has to take the test in order to get a job, and it turns out that this differentiates by eliminating a much larger component of one race than another race. Now, as we'll see a little bit later on, if it's directly related to the job, that's one thing, but if it has nothing to do with the job, if you, for example, write a test that you know that 80% of white people are going to pass and only 50% of black people are going to pass for whatever reason, and that has nothing to do with your job. You're hiring people to manage your food store, and the test that you give them is on complex mathematical algorithms or whatever it is. One thing has nothing to do with the other. That could be considered a disparate impact discrimination. Although, of course, if there is a direct relationship between the test and the job, then even if it has a disparate impact, there may be a justification for enforcing it. In order to bring an action under Title VII through the EEOC, there are some steps that an alleged aggrieved employee has to take. First, a private complainant would file with the EEOC, file a complaint with the Equal Employment Opportunity Commission. Then the EEOC is given the opportunity to sue on behalf of the complainants. For example, the EEOC can take a look at this and say, okay, well, we agree with you. We think you were discriminated against, and we're going to file a lawsuit. And of course, if that happens, well, then the EEOC will pay for the lawsuit and has a lot of resources. So obviously, that's probably the best scenario for the employee. If the employee, except for the case being settled where the employer gives in to the employee's demands, I guess that's the best case scenario. But the next best case scenario is where the EEOC says, yes, we agree with you, and we're going to file a lawsuit against your employer on your behalf. The EEOC might not think maybe it doesn't have the resources, maybe it's busy with other things, maybe it doesn't think that the cause of action is meritorious, maybe it doesn't think there's any evidence of discrimination. So if the EEOC, for whatever reason, chooses not to bring the lawsuit, it will issue a right to sue letter to the complainant. In other words, hey, complainant, person making the complaint, we're not going to file a lawsuit in your behalf, so now if you want to, you can bring your own lawsuit in federal court or even in state court, depending on the circumstances, and then the employee can either sue and go to court and see what happens, or not sue or try to settle, whatever the case may be. If there is a judgment against the employer for discriminating on one of these bases, well, then a successful plaintiff can recover back pay and reasonable attorney's fees. So let us now cross over to the idea of, okay, what is considered discrimination? Well, first, we've got race, color, and national origin discrimination. I'll call it race discrimination for short, but of course it refers to all of these. Title IV, the main reason why it was passed, it was part of the civil rights legislation, part of the Civil Rights Act of 1964, and it was intended to prohibit employment discrimination on the basis of race, color, and national origin. Race refers to categories of individuals based on, I guess, physical characteristics. Color obviously refers to the color of a person's skin. National origin is the person's ancestry or the person's cultural characteristics. Now, once the law was being passed, then the government figured, all right, listen, once we're trying to prevent discrimination on the basis of race and color and national origin, we might as well extend it a little bit. And so therefore they also prohibited discrimination on the basis of gender. And this applies equally to men and women and is very often used. So men can use it if only women are being hired, women can use it only if only men are being hired, or not even a matter of only, if it can be established by a pattern or even by an individual incident or by somebody who, if they get a smoking gun, they get somebody in an email saying, I don't want any women for this job, or I don't want any men for this job, or whatever it is, they can bring an action for discrimination based on Title VII of the Civil Rights Act. And then the last category is religion, where Title IV also prohibits employment discrimination based on a person's religion or religious practices. Now, that doesn't mean necessarily that an employer has to allow a religious person unlimited flexibility. If a person's religion, for example, says, well, I'm not allowed to work during the daytime, and so therefore I'm not coming to work any time for the next, as long as I'm with the company, well, obviously you can't expect an employer to be able to run a business like that. But an employer does is not only not allowed to discriminate based on religion, the employer also has to reasonably accommodate an employee's religious practices and observance if it doesn't cause an undue hardship on the employer. For example, if a person can't work on Saturdays and the company's normally open, well, then the employer would probably have to allow the worker to work a different day instead, maybe work Sundays instead, or something to that effect. On the other hand, if the job is a college football announcer where the games are all on Saturdays, well, then the employer doesn't have to make that kind of accommodation because it just simply doesn't make any sense. The whole business would be the whole effectiveness of the employee would be wasted because of the employee's religious beliefs or religious practices. Okay. Then now let's take a look at the opposite side of the coin, the defenses to a Title VII action. And there are a few others that we're going to discuss, but merit means where you say, well, it wasn't because you were a particular race or religion or gender that you got fired or didn't get a raise. It was because you didn't deserve it, or you did deserve to get fired, or whatever it is. Seniority. You are allowed to run your business based on seniority, give people who are there longer the better treatment, regardless of what their race or gender is. And finally, you've got the old BFOQ, or bona fide occupational qualification. A bona fide occupational qualification means, okay, yes, we're discriminating based on gender, yes, we're discriminating based on race, yes, we're discriminating based on religion, but that's because a particular race or religion is necessary, or a particular gender is necessary for this kind of job. So it's lawful if it's job related and it's a business necessity. If you're, for example, hiring a Christian pastor, well, I think it's pretty much common sense that you need somebody who's Christian to be a Christian pastor. So it's the sort of thing where if you're hiring a model for women's clothing, well, then you need women to model women's clothing. So that's the idea where you're saying, yes, I'm discriminating, but I have a reason why I need to discriminate, and that's called a bona fide occupational qualification.